Bienenfeld Law with Saul Bienenfeld.
Hi, everyone. Today I want to talk about a very important legal concept. It's called diminished capacity, when the mind blurs the line between guilt and innocence. I'm Saul Bienenfeld, criminal defense attorney admitted in New York and Florida. And today we're discussing diminished capacity. Now, you've heard the term before, maybe in a movie, maybe on the news, but in real life, it's not as simple as he was crazy. Diminished capacity sits in that gray zone between sanity and insanity, between guilt and understanding. And when it's used properly, it can mean the difference between decades in prison and a measure of mercy. So today I want to unpack it, what the legal standard is, how it affects defendants, a real case where I used it, and what it teaches us about justice and humanity. So let's start with the basics. In plain English, diminished capacity means a person's mental state was so impaired at the time of the crime that they couldn't form the specific intent that the law requires. Now, that word intent, that's everything. It's in criminal law, we talk about mens rea, the guilty mind. It's not enough that someone did the act. The prosecution has to prove that they meant to do it. So if the charge is murder, they have to prove the defendant intended to cause death. If it's burglary, they have to prove intent to steal. And if the person's mind was clouded by trauma, psychosis, brain injury, or addiction, that intent may not be there in the way the law requires. Here's where it gets tricky, at least in New York. New York doesn't recognize technically diminished capacity as an affirmative defense. Instead, we can introduce psychiatric or psychological evidence to show that the defendant lacked the capacity to form intent. Now, that comes from cases known as People versus Siegel, People versus Weinstein, and People versus Taylor. So it's not, I'm not guilty because I was insane. It's more like, I'm guilty of something, but not of that higher intentional crime you're accusing me of. In other words, diminished capacity doesn't erase guilt, it reshapes it. For defendants, diminished capacity can change everything. It can turn a murder charge into manslaughter. It can turn an intentional assault into a reckless one. And sometimes it opens the door to treatment instead of a cage. From a defense perspective, it also changes the story we tell. Because jurors are human. They want to understand the why. They want to know if what happened was a deliberate act or the tragic result of a damaged mind. I found that when you present mental health evidence effectively, when you bring in the right experts, when you let the jury see medical records, military trauma, addiction, or neurological evidence, the courtroom shifts. The jurors lean in, the prosecutor starts objecting more, and you could feel the temperature of the case changing. Now, the prosecution will fight tooth and nail. They'll say, he knew what he was doing. They'll pull up text messages, surveillance videos, any sign of planning, anything that smells like intent. And that's why diminished capacity cases require precision. You need a credible expert, a psychiatrist, or a neuropsychologist, someone who could connect the dots between mental illness and the specific intent element of the charge. It's not easy, but when it works, it is powerful. Let me tell you about a case that still stays with me. A few years ago, I represented a veteran charged with attempted murder in the second degree and assault in the first degree after a domestic altercation. The facts looked terrible. There was blood, there were threats, and the DA was painting him as a violent and dangerous individual. But when I met him, I didn't see a monster. I saw a man with untreated PTSD, depression, and a terrible history of combat trauma. He was taking medication, he was drinking on top of it, and suffering from flashbacks, nightmares. That made the line between war and home a blur. So instead of going down the insanity route, we built a diminished capacity defense. We brought in a forensic psychiatrist who diagnosed him with dissociative episodes tied to PTSD. We introduced his military records, his VA treatment files, his prescription history. We didn't deny what happened. We reframed it. The prosecution wanted the jury to see intent, that he meant to harm. We showed that what happened was a tragic outburst from a man whose brain had been rewired by trauma. And when the jury came back, they didn't convict him of attempted murder. They found him guilty of assault in the second degree, reckless, not intentional. He avoided a 25-year max sentence and instead got a term that included treatment. I remember after sentencing, the judge pulled me aside and said, "Counselor, you're expert, and your storytelling probably saved this man's life." And that's the power of understanding the mind behind the crime. Now, let me share another quick war story with you. Years back, I defended a young man with schizophrenia, charged with burglary. He'd walked into an apartment at night, sat down, and turned on the TV. He didn't steal anything. He didn't break anything. He just sat there. The state's psychiatrist testified that he knew right from wrong. So during cross-examination, I asked one question. "Doctor, if someone truly believes that the apartment they entered is their own, is that a burglary?" He paused, and for the first time in the trial, the courtroom went completely silent. The jury got it. They could see what I was saying. Not an excuse, but an explanation. The verdict came back: criminal trespass, not burglary. Outside the courtroom, I remember the defendant's mother gave me a hug and said, "You saw my son as a person, not as a monster." And that's what diminished capacity really is all about. It's about remembering that behind every case file, every docket number, there's a human being, often someone whose mind broke long before the law caught up with him. When I teach or mentor younger lawyers, I always say every criminal case has three stories: what happened, why it happened, and what could be done about it. Diminished capacity is about that middle story: why it happened. It forces us to look at how trauma, addiction, brain chemistry, and environment shape behavior. It reminds us that mental illness doesn't always announce itself loudly. Sometimes it hides beneath anger, silence, and bad decisions. For me, as a defense lawyer, diminished capacity isn't just a legal doctrine. It's a philosophy. It's the belief that justice should be informed by compassion, that a personal mental suffering should not be ignored in the pursuit of punishment. And honestly, in a system that often prefers punishment over understanding, that philosophy matters. So that's diminished capacity, not as Hollywood imagines it, but as we live it in the courtroom. It's a reminder that the mind itself can be part of the crime scene. Every time I walk into a courtroom, I ask two questions: what happened? And more importantly, why? Because sometimes understanding why is what brings us closest to justice. Thanks for listening. If you found this episode insightful, subscribe to my YouTube channel, share it. Join me the next time as we keep exploring the human side of criminal defense. One case, one story, one life at a time.